We're now in public session, and I'd like to welcome our witnesses this morning. Patricia King, General Secretary of the Irish Congress of Trade Unions, Billy Wall, Chair of the Congress Construction Industry Committee, Seamus Dooley, Irish Secretary of the NUJ, and Brendan O'Hanlon, Assistant General Secretary of Forsa. You're all very welcome. In a couple of moments, I'll invite our guests to make their presentations to the committee, and when they've concluded, then I'll invite members to put questions to them. And to the members, I'd remind you to maybe confine those initial round of questions to about 5 minutes. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the committee to cease giving evidence in relation to a particular matter, and you continue to so do, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person, persons or entity by name or in such a way as to make him, her or it identifiable. And members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official, either by name or in such a way as to make him or her identifiable. And just before I begin, if any of you have mobile phones, you might switch them off or to flight mode, please. Okay, Ms. King, you're going to do the opening statement, and remember, when the questions come, you can, whoever feels qualified and suited to the answers, all feel free to contribute to that session. So we'll start with the opening statement.
Thank you very much, Chairman. And I'd like to begin by thanking you and the other members of the committee for the invitation to attend today's hearing. And I'm joined by Billy Wall, Chair of the Congress Construction Industry Committee and also General Secretary of OPATSI. Unfortunately, Karen Loughlin couldn't be with us today, but Seamus Dooley, from the National Secretary of the Union of Journalists, and Brendan O'Hanlon are from Forsa are with us. The practice of misclassifying workers as self-employed has been a problem in Ireland for a number of years. And when a worker is misclassified, there are very negative consequences for him or her and a significant financial loss to the state. However, there are very significant benefits to the person who in normal circumstances would be his or her employer. And this incentive has led to a number of employers in a number of sectors of the economy seeking to misclassify workers. So there are very negative and serious consequences, I've said, for workers misclassified, and because their employer is not required to pay employers PRSI, they are not entitled to the full range of social welfare benefits. They are also denied access to the suite of employment rights which are available under the Irish and European employment laws rights legislation. There are also very serious consequences for the public finances and the Exchequer. In the following sections of this submission, we will seek to quantify the loss of tax revenue that arises from workers being misclassified. However, for the employer who forces a worker to work as self-employed, there are very considerable financial benefits. So it too has been highlighting the problem of bogus self-employment now for many years, and we've encouraged government and its agencies to act to resolve the issue. However, any action which has been taken has failed to correct the problem. Over the last year, 2 significant reports have been issued which have sought to identify the extent of the problem. In January 2018, the Department of Employment Affairs and Social Protection and the Department of Finance published a report entitled "The Use of Intermediary-Type Structures and Self-Employed Arrangements, Implications for Social Insurance and Tax Revenues." The Revenue Commissioners was also involved in the preparation of the report. This report showed that in the period between 2007 and 2017, there was an increase in the level of self-employment in 7 of the 14 major sectors of the economy, which make up the CEO NACE series. The report also highlighted the very high rate of self-employment in the construction sector when compared with other sectors. The report also examined the potential loss to the Exchequer arising from the misclassification of workers as being self-employed, and the following is a direct quote from the report. Although illustrative, The data does indicate the potential loss to the Exchequer for a person engaged in work at a rate equivalent to the average industrial wage, which is €37,500, amounts to €5,000 per annum. This rises to €8,000 per annum at a payment level of €60,000 and €15,000 per annum at a payment level of €100,000 per annum. The annual report of the CNAG, published in September 2018, also examined the issue of self-employment, with a specific emphasis on PRSI contributions by the self-employed. As part of that report, the work of the Special Investigations Unit of the Department of DEASP and the Joint Investigation Units were highlighted, and the report notes that in 2017 the JIU initiated a campaign specifically focused on the construction sector. As a result of this activity, €60.2 million was recovered by the Revenue Commissioners, and nearly 500 subcontractors reclassified as employees. The CNAG concluded that because there is no employer PRSI contributions for workers who are classified as self-employed, this creates an economic incentive for certain individuals to be improperly treated as self-employed. The report went on to make a number of recommendations, including an increase in the level of compliance activity. The CSO Labour Force Employment Series shows the numbers of employees and the numbers of self-employed people across a range of employment sectors. In particular, the number of self-employed people without any employees is detailed. For example, in Q2 of 2018, the percentage of people classified as self-employed with no employees in construction was 24.3%, while in transportation and storage it was 14.8%, and this compares with 3.9% for industry in general. The CSO data also shows the number of workers classified as self-employed with no employees in construction has increased by over 6,000 in the year to Q2 of 18. The issue of bogus self-employment was recently discussed in the Oireachtas as part of the debate on the Employment Miscellaneous Provisions Act 2018. During the debate on Wednesday, the 19th of December, the Minister for Employment Affairs and Social Protection made the following comments. The one thing I can safely say is that we are all in agreement regarding the fact that there are people in this country who are made bogusly self-employed through no fault or acquiescence on their part. I totally accept and appreciate that we have a difficulty in this country with people who are bogusly self-employed. Congress believes that the problem of bogus self-employment is a very significant problem and needs interventions at a number of levels. And I want to take the following few minutes to go through some of the ideas that we have developed, which in our view will go a significant way towards resolving the issue. Congress is calling for the following control measures to minimise the risk and to detect the fraudulent misclassification of workers as self-employed. Workers should only be permitted to register as self-employed if they satisfy agreed criteria. And in 2012, Revenue discontinued the old paper system for the registration of contractors and moved to the process online. We are of the belief that all semblance of effective monitoring and control disappeared with the move online. During and under the new system, an employer or principal contractor can go online, designate any number of employees as self-employed without challenge. Congress recommends that at a minimum, workers without a taxation record no longer be permitted to register or be registered on their behalf as self-employed unless they satisfy strict criteria laid down in an agreed code of practice. Make principal contractors liable for employer PRSI for all subcontractors. There is no employer contribution for Class S PRSI contributors. In his report of September last year, the CNAG notes, this creates an economic incentive for certain individuals to be improperly treated as self-employed. Indeed, earlier in the year, DEASP and the Department of Finance, in a joint review of bogus self-employment and the implications for social insurance and tax revenues, recommended reducing the differentials in social insurance rates in order to reduce the economic incentive. Congress is encouraged by comments by Minister Doherty in an interview with the Irish Times earlier this month, in which she signalled her willingness to introduce legislation for a new so-called contractors' tax, in line with international best practice, whereby contractors are made liable for employer PRSI on behalf of workers they contract to provide worker services. Congress looks forward to engaging constructively with the Minister and her officials on the operational and design features of this important amendment to PRSI. The Workplace Relations Commission Labour Courts replaced the Department's scope section in reviewing reported misclassifications. It is the firm view of Congress that the safeguards in place for workers incorrectly classified as self-employed are not timely or sufficiently robust. Requests to have an employment investigated to ensure that the correct class of PRSI is applied are currently dealt with by the scope section of DASP. Congress calls for the reviewing of reported misclassifications to be moved to the WRC or the Labour Court. Strengthening Revenue's capacity for PRSI non-compliance intervention. Both the Department and the Revenue engage in compliance activity in relation to PRSI. Targeted investigations recently undertaken in the construction sector by the two detected a significant incidence of misclassification. Congress calls for the necessary resources to be made available to increase the level of compliance activity. Backdating unpaid PRSI in full from employers found to have misclassified workers. A determination finding that a worker's employment status has been incorrectly classified should always result in PRSI contributions being backdated in full. A universal cap or case-by-case limit on retrospective payments not only serves to undermine it as a deterrent to rogue employers, but it leaves the worker's social insurance record unnecessarily incomplete. Legislate to clearly define the term worker-employee. The term worker and employee are not defined in employment law. This results in ambiguity on how to determine whether to engage workers in a contract for service or directly as employees, increasing the risk of misclassification. While a common understanding is currently being negotiated at European level, Congress calls for domestic legislation that clearly defines the terms to be introduced without delay. We have included as an attachment a one-page document which seeks to summarise the points made in this submission, and I would like to thank you for your attention, and we're happy to take questions. Chairman, thank you.
Thank you very much for your opening statement. I'll take questions from all of the colleagues first and afford you individually then a chance to respond to them. And colleagues, if you confine your first round of questions to 5 minutes, I will come back to you all for a second round, but to be fair to everyone. Deputy Brady, if you'd like to go first.
Thanks, Carey. Look, and I'd like to welcome you all in this morning. A very informative opening statement, and particularly the one-page summary. I think it is very, very useful, and it really just gets to the point of the problems that we're experiencing, the contributions, PRSI contributions that the state is missing out on, and I suppose the extent of the problem. And there's one line in your opening statement there. You say Congress believes that the problem of bogus self-employment is very significant, and I think that absolutely is very true. And I think that unfortunately contradicts what the Minister or her officials had said at our previous hearing, when they stated that they didn't think the problem of bogus self-employment was extensive. So, there's obviously differences there. I side with yourselves. I think it is very significant. I think it is endemic right across our Irish economy, and particularly now when we see particular sectors starting to pick up, the likes of construction and that. And I just want to ask one point there, because I was just reading through a paper that Congress prepared back in 2015, False Economy. And at that stage, Patricia, I think you had estimated that the state was losing out on roughly €80 million in PRSI contributions on an annual basis, a figure of €640 million between 2007 and 2015. So that's obviously not just very significant. It shows, in my mind, that it is widespread across many, many sectors. So that was 2015. We know the economy has picked up. Construction and a number of different fields have picked up as well. So can I just ask, those figures obviously stand over the figures back in 2015. In your estimation, would there be a significant increase on those figures over the last 3-4 years? Would you care to put a figure on what you think the estimated loss to the department, to the state, in terms of PRSI contributions roughly would be at this point, or as to whether you have done any analysis on it at this stage? Just in terms of point 7, in relation to your opening statement, you outlined that you have been calling on government, the department, to address the issues. Can I just ask what I suppose steps have VIC2 taken in terms of what you have been saying? Have you met with the department? Have you met with the minister or previous ministers in this regard? And can I just ask, because we heard a lot at our previous hearing from the department, but I don't think the department is sufficiently resourced to seek out bogus self-employment, and we see the huge resources that were put into the social welfare cheats campaign, which I have my own particular views as to what the purpose of that was. It coincided with an election campaign within Fine Gael, and maybe he was trying to show who was more right-wing than the other, but I don't see the same type of campaigns being rolled out for the real significant cheating that is going on in terms of PRSI contributions on one hand, but also the workers' entitlements and rights that they're being denied by this practice. So just to see as to whether you think the department is sufficiently resourced to seek out bogus self-employment. And just in terms of the WRC and the Labour Court, would you prefer to see the WRC and the Labour Court take on the reviewing of reports of bogus self-employment? And in again, your opening statement, you make a number of references to the construction sector. You also, there's a line there just talking about transportation and storage. Self-employment was 14.8%. Self-employed in that field. What other areas do you think there's significant problems? Because we have heard, for example, in fairness to Phil Boucher-Hayes in RTE, he's done an awful lot of work in terms of practices in the state broadcaster in RTE, and I know there's been different, I suppose, internal reviews of practices, work practices there, but it seems to be certainly widespread in that sector as well. So just if you could outline other areas that you think there are significant problems of bogus self-employment. And just final point there, just on a practical note as regards your own members, how often would issues, reports of this nature, bogus self-employment, be raised with yourselves? Is it, on a daily basis, or, how often would those be raised? And just a final point, because the recommendations, and I think they are key, because we know all the problems that are out there. The recommendations are obviously key to addressing all of this. There's one recommendation there, just in terms of making the principal contractor liable for employer PRSI. Just, what rate would you like to see that set at? And the final question there, just in terms of, you cite since 2012 registration of contractors, the paper-based application process that was in place up to that was removed. It was an online process. Do you think since 2012 there has been a significant escalation due to that single measure that was changed in 2012? Do you think the evidence that you have seen and has resulted in a significant increase in bogus self-employment?
Thank you. And we will hopefully have an opportunity to come back for a second round of questions. Deputy Collins.
Again, I'd like to thank everybody for coming in today. This issue of bogus self-employment, it really has, I think the first case taken to social welfare was back in '93 by couriers in relation to the classification of their job. So it's been in the ether for the last nearly 26 years from the point of view when it really began to take off, and then in the 2000s onwards it sort of moved right across the whole section of workers in the construction industry. Now, the reason why we're having this discussion here today is because the committee wants to have an investigation into how deep the bogus self-employment is in industry, because we've been told by the construction industry there's not a problem here. We've been told by the Minister, even the response from the ad last year, we were told there wasn't a big response to it, so it's not really an issue. But yet we're hearing on the ground right across the board that it is a big issue. So maybe the question to each of you is where are you seeing it? In what type of jobs are you seeing it in your own industry? Have you taken many cases to the scope in the department? Where I see the big problem is that scope does actually give adjudications in favour of the employee. They have to take them on individual cases. You can't take them as a broad group. But it's when it gets to the Social Welfare Appeals Office that things change, and more often than not, that's where the workers lose out and the employer gains. So, you know, where are you seeing that? Because I really think we have to do a really good investigation of this and be able to give a report to say things need to change. And we have got legislation being proposed from, I think it was Fianna Fáil in the last bill we had before Christmas, has been mentioned. But we want to bring in a robust piece of legislation with the support of the unions and obviously the Minister in relation to this. So in each of your industries, where did you see it beginning? In what areas is it prevalent in? How many cases have you taken? And your opinion on the scope and the Social Welfare Appeals Office. And I'd say that's why you're making probably the proposal that it should go to the case should be taken out of the hands of the department and brought into the WRC specifically to deal with the cases. So maybe you could fill us in on that, the thinking behind that as well. So I'm going to leave it at that because a lot of questions have been asked already, and just really is to get deep down into industry to see where it's really happening.
Thank you, Deputy Collins. Senator Higgins.
Thank you very much, and thank you for joining us today in the presentation and indeed the advocacy work around this issue, which I think has been very, very important from the unions, particularly in that in some cases it's representing those who may not yet be members of the union or be in a position to be, but recognising that there is a whole cohort of workers affected. And I had a few points. I think what came across very strongly, and I thank you for making it so clear, was that it's not simply a matter, as we've outlined, that the deterrent is inadequate in terms of employers practising bogus self-employment, but that there is in fact an incentive and a danger. And if you could just come further on that question of perverse incentive. So are we basically in danger of creating a wrong incentive where in fact there is a reward for employers, and I think you make that very clear. In terms of the deterrent, it was very striking. It's been very striking, the huge lack of prosecution and the lack of taking things forward. I think about 21 cases in the last few years, and none, as I understand it, in 2017. Even this despite the fact that, as I think you had, such a huge cohort of the main areas of work in the state are affected by this, and that we're looking at rates, as you said, of about almost a quarter of those in construction. Specifically in relation to construction, Mr. Wall, you might comment on, it was interesting to see the Revenue Commissioner actions in 2017 that are discussed there, where you had a large number of subcontractors reclassified as employees, and yet later on we learn that we've now 6,000 more in that sector. If you could kind of comment, because it helps us to think about how we can really interrogate sectoral investigations, because one of the things we discussed was the issue whereby individuals are taking cases and they may or may not have satisfaction, but a big concern was that these individual cases are not extending into sectoral analysis and really wide-scale change. So, for example, if one employee of a company engaged in a type of work brings forward a case, that should, of course, trigger a wider review of both that company and indeed of that sector. So maybe if you talk about having had that investigation and did it or did it not have the ripple effects. I think it's also it's very striking in terms of the loss to the state as well. Not simply in terms of those who may end up dependent on other forms of income, the loss to the active economy, but also in terms of pensions. If perhaps you might comment on the long-term impact of bogus self-employment, particularly in a climate where we now know that we are likely to move to a requirement for example, 30 pension contributions for a full pension, or as is sometimes touted, 40, but I'm hopeful that we will be able to keep it at 30 pension contributions. In terms of it, so I mean, I imagine that this is putting a huge cohort of persons out of reach of that pension. I had one area where I had a question. I kind of have concerns. I've heard it spoken about. The suggestion that has been made by the Minister around making principal contractors liable. While I can see potential positive things in regards to some aspects of this, in that I think quality employment should be reflected in all contracting and tendering processes, and an expectation of quality, and indeed an expectation of progression in employment should be seen. I do have questions and concerns in relation to this issue in certain areas. And so, for example, in areas like where we have public procurement, and perhaps you might comment specifically on public procurement and how it should be ensuring that it is not contributing to bogus self-employment. And I'd really appreciate if you could identify 2 or 3 areas of public procurement where that could be tackled, because that's something we have a great scope to tackle. There is potential there in terms of quality public procurement, but in terms of this specific proposal, I am concerned in relation to the question of liability. So, for example, if in the construction area you look at the area like home renovation, if you have a situation whereby the individual who's renovating their home is somehow the person liable for PRSI, you know, is there a danger of that in this proposal, where basically we're distancing again, employers are almost getting off the hook again, and we have individuals, because it's very, of course, difficult for an employee or somebody named as a self-contractor who is in fact an employee to really take action against individual small contractors, if you know what I mean, are contracting, rather than those that they are effectively working for. So I have concerns around that proposal, that it distances us. My last 2 questions in relation to the Workplace Relation Committee and the Labour Courts. I think it's very positive, the idea of bringing them into the process, certainly, if not replacing scope. In terms of, at the moment, we've seen that scope is appealed back to the department, and that's not the right thing. But if you've had trouble, we've heard cases of people having difficulty because they're almost in 2 processes at the same time, trying to navigate the labour courts and at the same time trying to navigate the process around their registration. If you could just comment on that, would be very. And then finally, just to Mr. Dooley, I know that you have worked extensively with many people in the arts. And I know I spoke last week in terms of precarious employment in the arts, where it is, you know, endemic, and particularly contracting. Have you found, for example, the Competition Amendment Bill put forward by my colleagues here on the committee, and that the collective bargaining possibilities in that area, has that in any way assisted in terms of tackling this issue in that sector? Thank you.
Very much. Senator Nash.
Thank you very much, Chair. That's a question I'd like to maybe tease out with Seamus later on in the proceedings as well. My, I guess, initial appeal to the witnesses today would be not to put a tooth in it, to be very clear about what the practice involves on the ground, because I think it's fair to say, without putting words in the mouth of colleagues around this table, Oireachtas members, that we're very clear in our view in terms of what needs to happen. In terms of providing more significant deterrence and more legally robust provisions around the practice of bogus self-employment in law. But I think it's fair to say that the Minister and her officials, and indeed officials from the Department of Finance and Revenue, may take a different view about the approach and also about the level of activity around bogus self-employment. I mean, I'm very clear on this. I mean, the practice of bogus self-employment amounts to nothing short of fraud. It's a fraud on the state, it's a fraud on the taxpayer, and in my clear opinion, it is a matter of corruption on a mass scale. The state can have all the inspection regimes and investigation systems and deterrence as it sees it in place that it wants, but the numbers engaged in bogus self-employment are growing. The figures are very, very clear. And it's not just a phenomenon, of course, that's exclusive to the construction sector, where it may be most apparent and where members might see it most clearly. But we know that this practice is now endemic in the transport sector, in IT, and it is growing as well in legal services and financial services as well. And it seems to me very clearly that the legal deterrents just simply aren't there. They're just not there. And we do need, and I agree with Patricia King, very clear legal definitions anchored in primary law to define very clearly the difference between employment and self-employment. And I think we could learn something from the legislation that myself and my colleague Senator Bacic worked with the NUJ, SIPTU and Congress in general on the Competition Amendment Act, and I appreciate the view of witnesses in terms of what we can learn from that and how we can apply some of those provisions to the broader population, as it were, to try to deal with this issue and the broader consequences of the gig economy and implications for people who are in employment. Would witnesses agree that we need to treat PRSI cheats, and that's what I call them, the same way that we treat tax defaulters? And you'll know that legislation that I developed that got through second stage last year is attempting to wind its way through the Oireachtas, and I see this process here as providing more significant evidence to compel the Minister to move that legislation on to second stage, because we need those legal deterrents, those clear legal definitions in law. But that legislation, that proposed legislation, insists that we treat PRSI cheats the exact same way we treat tax defaulters. Crime, treat it as a criminal act, provide for criminal sanctions, ensure that we can recover the PRSI sums that are lost to the Exchequer, and ensure that there are more serious fines in place, because, as I understand it at the moment, the fine for not paying the appropriate level of PRSI amounts to about €3,000, and I can't identify a single case where somebody has been jailed for not paying PRSI and for pulling the wool over the eyes of the taxpayer and the state and essentially defrauding the state. There absolutely has to be a stronger role for the WRC in this whole process, and I introduced, as you will be aware, a provision in that legislation that passed second stage last year to provide for that stronger role. And I'd really be interested to hear your views, Billy, in relation to that, in relation to a greater function for the WRC in determining employment status, because I know that you, as a representative of construction workers and people like Paddy Kavanagh in Connect and others, have a number of cases that you managed to get through the system and have very interesting determinations from the WRC, and I'd just like to tease that out with you to see the implications of that. A question for Seamus Dooley, again it goes back to the Competition Amendment Act and what we can maybe learn from that in terms of transposing the definitions there in relation to employment and self-employment, the characteristics of employment and self-employment, into legislation more broadly, because as we know the Competition Amendment Act itself applies to session musicians, freelance journalists and voice-over actors as well, but it also provides for a route to collective bargaining for very exposed freelance workers. And I'd like to I'd like it if you could elaborate to the committee what progress the union movement is making in terms of trying to organise very vulnerable workers, because I think that provides, again, another fix maybe for addressing some of the worst excesses of these kinds of practices. Just Billy, as well, if we can return to you, you might just reflect a little bit and tell us about your experience in terms of addressing the skills deficit in the construction sector, because in my own experience in my own constituency and from speaking to construction unions, it has proven to be very, very difficult to attract apprentices into the system because they have no guarantee of permanent pensionable employment, which is something I think they should be entitled to expect given the skills that they will develop and given the requirements that this economy has for skilled construction workers into the future. Brendan, just if I can conclude, Brendan, you might just elaborate a little bit on your own experience and the experience of Forza and IALPA around trying to organise pilots who are being forced into situations where they are involved in intermediary type arrangements, which they're required to do by some airlines to allow them to work. And just finally, if I can, just a question for Patricia. It's been said that this practice really amounts to illegal state aid, because what you're doing is querying the pitch competition-wise. You're allowing some rogue employers to take all of the benefits of this as they would see it and to lead to an imbalance in terms of competition in the sector. I mean, some employers, and Billy Wall and others know this, there are some good construction employers who will engage in sector employment orders and so on and want to retain and recruit quality staff, provide them with the legal, basic requirements of the job, but there are others who won't. So it could be argued that the growing tolerance for bogus self-employment amounts to something akin to illegal state aid, and I appreciate Congress's view on that. So I'll leave it there for the moment.
Thank you very much. No.
I listen to you.
Just before I suppose give you an opportunity to respond. A number of people have talked about, you know, in terms of I suppose, it being made more difficult from the point of view of employers getting away with it, fines or whatever being greater. But one of the concerns, and I want to put to you the department's view, because I have a concern about this, that the number of cases they're unearthing are relatively small. So you very specifically talk about the WRC and the Labour Courts replacing the scope section, and I think it's something we need to have a look at. And I want to specifically just give you these numbers. In 2017, the scope section made over 1,000 determinations. It's 1,097 decisions, and of those, 138 resulted in people being determined as Class A, and the department's own wording was 35 could be described as disputed employment, self-employment cases. So, and then they talk about the rate of appeals. The rate of appeals in any given year is 5 to 10%, and approximately 20% are overturned. So the figures in that year in terms of what went through the scope section and what came as Class A were relatively small. And secondly, I want to refer to the evidence given at the committee by the department, where they talk about their inspection work and whatever. And specifically, I'll quote you this bit. The department, in conjunction with Revenue, a number of inspections in the construction and other sectors were carried out in the West in the second half of May 2018. The focus was on establishing correct insurability class and on challenging any cases where dubious self-employment subcontracting was suspected. Leaflets outlining the false self-employment campaign were issued, and the main contractors and others as considered appropriate. The joint Revenue DESP Special Investigation Unit inspectors were undertaken in Galway City on the 10th of May on 3 substantial sites. A total of 163 people were interviewed on the sites. 10 of these workers were identified as self-employed contractors or stroke subcontractors, of whom just one was supplying labour only. A follow-up investigation regarding insurability is underway in this case. Although not a determinative in relation to the overall scale of the issue at national level, the result of the inspection yielding just one case, one suspected case of false self-employment, is consistent with the LFS data indicating that false self-employment may not be as common as the prevailing narrative suggests. That was from the department's point of view. So the concern I have is, has the department and the Revenue, the joint investigations units, have they the capacity to unearth and determine, and has the scope unit the capacity? Because the figures that they're unearthing and showing up are relatively small in comparison to the narrative that we're hearing, whether it's in construction or whether it's in transport. But the figures in terms of the investigations, the annual figures going through the scope section, don't seem to be unearthing the figures that we believe they should be. And you might like to comment on that in your replies. Patricia, a range of issues. If you want to start, and then each of your colleagues take.
Okay, and thank you, deputies and senators, for the questions, and chairman. So, if I might maybe break this down into a few headings that seem to have come across through the questions, to try and address those as accurately as I can. I'll start with the question: is bogus self-employment cheating? The answer to that is yes. So let's have a look then at the queries that came, the questions that came about amount. Well, you don't have to, some of you would be happy to know, just rely on us in relation to potential loss to the state or our figures on it. Just have a look at the report that the CNAG did in November of 2018. And I'll match that with some of the CSO figures to give you an estimate of what you could be looking at here. Now, I'll just say this to you. We have been going around the houses with this. I'm associated with it for 15 years and maybe longer. But then that Competition Act that we got through took 12 years to get it. So there's a long haul in any of this that you campaign on. So just have a look at what the CNAG said. The CNAG said a person on 100 grand paying tax and PRSI in the normal way would have a yield to the state of would have a yield 44,600. So if you come to a self-employed person, the take to the state would be 29,648, and for a person operating through a company and so on, take from the state or to the state would be 29,900. Now, the difference between the two, so the PAYE contributor and the either self-employed or company person, is 15,000 per individual for the 100 grand. Okay. Now, if you go then to one sector, I'm going to pick one sector because it's the sector showing the biggest figures, and the CSO in their most recent, and I went to the CSO and I asked them to prepare those figures specifically for this purpose, because I knew we were coming here and I wanted to be as accurate as I could in the figures that you were going to hear. And they did that, in fairness to them. And they gave me the highest sector is construction, showing with self-employed with no employees. Big indicator, okay. So, if you take the figure of 100 grand and 15,000 loss per person, and if you take the whole 32,000, now it wouldn't be entirely right to take the whole 32,000 because there would be some people who are genuine. I actually married one of them. He doesn't have employees, but he's genuinely self-employed, if you understand. So you'd have to take a few of those. Engineers, architects fall into that sort of category. So I always have to say that because I have to be careful, because I usually have to go home. But anyway, if you take the 32,000 and you do a simple exercise and you say 32,000 self-employed, no employees, 15 grand if they were all earning 100,000, would be a loss to the state of 480 million. Now, again, not having an accountant's background, but I would say it might be safe to divide that figure in two. So you're talking about the 50 grand and you're talking about, and so you're looking at a 240 million in one sector possible loss to the state in both PRSI and tax. This is not just a PRSI problem. This is a tax issue as well. Okay. I will take that then and say to you that without, and one of the senators urged us to be stark and straightforward, by any standard, looking at that, that is potential huge loss to the state in money. And that's a fact in my judgment. And all of those good, solid indicators of figures, I didn't make it up. The CNAG was bold enough to go out and put that in the report. People have very strong respect for that office and what they do on behalf of the state. There you are. There's one very strong indicator from one sector. I'll move on then and draw that into the question that was asked about public procurement. I'm very glad that question was asked because it's something that I have tried to raise on numerous occasions, and certainly in certain quarters people either look at me as if you've lost the plot or you don't understand what you're saying. And I'll give you this example. In a public procurement situation for, let's stick with the construction industry, and there's a big public, and there's going to be in the 2040, we're told, lots of public money spent, taxpayers' money spent, building roads, building hospitals, building schools, doing all that. So it's essential we get this right. So if you take that situation where there's a public procurement for a big project and a real donkey load of taxpayers' money going to go into this project, I have asked the question, what is to stop the following scenario? And the following scenario is that a contractor goes in and tenders for the job, big job, tenders for the job on the basis of the following. All the workers will be directly employed. All the workers will be paid the sectoral employment order, which is the rate for the job through the House of the Oireachtas. And the quantity surveyors, or the people who put all these figures together, put in the price to the state for doing the job, with everybody being directly employed and everybody receiving the rate. Okay? That's the cost to the state. And that's what the state would want to see happening. Now, the job happens, the contractor gets the job, goes onto the pitch and starts to do the work. on the site. Big job, big public procurement money. I would have a big question mark over, are all the jobs direct and are all the jobs paying the SEO? Because if they're not, the state has committed to pay this price for the contract to be concluded. That contractor is going to get all that money. What's the difference now? Where does the money go when you start putting employees, they're no longer employees and you're not paying the PRSI? You've charged the state for it. You've charged the state for it. And you've charged the state for paying everybody the proper rate. I know of nothing that happens for anyone to go out and check to see if that's the case. Big money loss in my judgment, or potential money loss there if there is no monitoring of that. Very few people actually take that on when I say it, by the way, but it is another feature. So you ask for the loss, and our judgment is there's two major potential areas of loss that this state could put right if they had proper procedures in place to do it. That's that piece. So the next question arose, and I'm sort of taking the lead from Deputy Brady's questions because he sort of maybe touched on all the issues that topics that were raised by other questioners. So if you take, are we sufficiently resourced? Well, and that leads, Chairman, to the question you had asked about the scope section. Well, I'll just make a comparison. The scope section, you make reference to the contribution from the department when they were here to answer questions, and they talked about the 1,000 and so on. Well, if you look at the figure of when the JIU and the SIU, which is the combination group which the trade union movement were involved in and putting together, by the way, or seeking to have put together way back. And if you look at what the CNAG said, when that investigation happened, there was 5,017 interviews. 5,000 in 1 year, 5,000 in that sector, 5,017. They got 60 million tax back, right? And they got 484 subcontractors reclassified and 749 individuals put back to be re-entered as employees. And the CNAG says that's a 24.1% misclassification. We have a serious difficulty, a significant difficulty in that sector. Now, you match that against 1,000 across all sectors. I rest my case in terms of the productivity levels on that. Now, the reasons are, we're told that there's 117 people and 17 guards attached to the whole investigation units and so on. And we're told that our judgment is, to be fair to the scope section in the department, our judgment is that the resources are not there. Now, let's have a look at the WRC.
Sorry, can I interrupt you for a second? Will everybody just check their phones in case somebody has flight mode, or flight mode is perfect or off, but it interferes with the recording and the broadcast as well.
Yeah.
Sorry for that.
It seems to me that if we take the issue of resources, the resources everywhere are quite deficient in this. They're deficient at the WRC. There are about 57 labour inspectors for the entire economy. There are these 117 people, we're told, within scope that are utilised to do this work between the joint investigation units and the scope department itself. So there's 146,000 people employed at the moment in construction, and that's one sector. 32,000 of them are declared as self-employed with no. Now, where would you be going with 54 labour inspectors and the investigation unit and the small number of people that are directly employed in the scope section to counter that? So, why wouldn't there be a development of a view that you can actually do this and nobody will deal with it? So, we talked about the paper system and we talked about the online system. But actually what happens is a contractor now goes online, fills in all the details, designates people, classifies workers as self-employed, and nobody questions it. And one of the reasons is very clearly highlighted in the CNAG report, because the Revenue Commissioners do not view themselves as having any role in querying or questioning any of that. They are mere collectors of the money into a fund, and they pass it on to the Department of Social Protection, but they have no role, they view, in terms of either querying, questioning, seeing if there are any, and they do have apparently some phone calls every now and then happen between the Revenue and Social Protection if there are trends, apparently. Now that's what they do, that's how the system operates. So we felt that when the paper system was there, people were going through these papers and maybe something would be picked up, but actually it's not any stronger than that. The wholly all of it is that Revenue have no function, and they don't. I went and I met the chairman of the Revenue Commissioners, very nice man, talked to us and so on, but was very clear about what their functions were. Their functions are not to be doing, they collect it, and they do it sort of as, we do it because it makes life easier for the state to collect the money in that way, but it ain't our job now to be going after questioning or querying any of that, and that's in the case of PRSI. They do have a different view in relation to income tax, obviously, because they have a different role altogether. So just to say that to you, so there is a dysfunctionality, would be our judgment, in relation to, but doesn't it suit those who utilise it to have that dysfunctionality, and hasn't all this is roaming around the system and operating based on that dysfunctionality, because hey, nobody is going to stop us, we're going to get away, we're going to be able to do this, and so on. The other big prize, and we have it in our list that we sent you as an appendix, is apart from the economic incentive of not having to pay the employer PRSI, which is 10.9% now, which is a big economic incentive, apart from that, they divest them, the employer divests themselves of all employment law responsibilities. So you don't have to be dealing with that gang called the trade union looking after these people who have this, that, their pensions, apart from their pensions, social welfare contributions, which will damage their chances of income at a later stage in their life. But if there's any issue about holiday pay, if there's any issue about anything to do with their employment on the site, if there's any, sure, why would you not want that? Sure, isn't that the panacea that they look for? So from that point of view, this is highly imbalanced scenario, leads to all sorts of difficulties, which my colleagues will talk to you about, on if it's building sites or indeed in any of the other areas that this is utilised as a mechanism. So from those resources, no, from our point of view, they're not there, and the state is going to have to make a decision about that. Now, I take the points that have been made in relation to this proposition that could be coming, and it's certainly set out there in terms of the end user. I think that's a bit of a cop-out if I'm to understand it, but because what you'd be doing there is you'd be letting the contractor put the price back onto whoever's getting the job done, which to me is just, I mean, the fact of the matter is we should be able to classify people properly. Workers deserve to be classified correctly, and we should be able to do that and just have a system that supports that rather than this stuff. Now, the other option that's coming, which we say in our presentation to you is somewhat welcome, and is welcome, is this whole issue of the contract, drawing in the contractors to pay more money. But actually, at the moment, the manner in which the propositions are coming from the government, and indeed decisions have been made in relation to self-employed, has now got severe implications for the Social Insurance Fund in its very right, because they're now saying if you're self-employed, you pay 4%. That fund is under huge pressure, 70% of which goes out in terms of state pensions to people who've reached their retirement. And the most recent audit or actuarial review of it says it could be in severe difficulty by 2035 financially. Well, why wouldn't it be if you say to one group you can have all the benefits for 4% and the rest of us can only be in it if we have an employer to match us with the 10.9% and our 4%. So there are big issues all around. There was a suggestion by the tax strategy group of the Department of Finance when they, in 2017, and they made a recommendation that the contributions from self-employed should be proportionate with the benefits that they would get, and they estimated that proportion to be 12% of a contribution. That was their estimate, that it would be 12%. Now, clearly, if there was a decision made to have a proportionate contribution into the Social Welfare Fund from self-employed people, I'm slowly doing away with my chances of going home anyway, peacefully, but anyway, if there is a chance to get people in self-employed at 12%, and that's regarded as the proportion, then what you would see, the economic incentive would lower greatly for employers because everybody would have to pay this 12%. So these bogusly self-employed, misclassified people, instead of paying 4%, actually they'd be paying 12%. So that would be a much different. I agree with the Minister if that's what she's talking about. In other words, if she's talking about setting the rate at an economically would be disincentivised rather than incentivised. So I think that that deals with the perverse incentive, I think, so that a lot of work needs to be done by the policy developers and policy makers in relation to putting that right. So I think I've dealt with the financial piece, I've dealt with the public procurement, I've dealt with the perverse incentive, and I have, I think, dealt with the resources. So maybe I would also just say to you, there is some hope, possibly, if the EU directive, although as this phrase "time is running out" seems to be used for everything now, but if the Transparency and Predictable Work Directive were to come through, it is possible that you would have a better definition of the word worker and the meaning of the word worker, which might very well be helpful for the classification and bring a decline in terms of the misclassification. But I gather that from our research and from our knowledge, the government here has not been advocating in line with what has been put forward at these various different EU Commission meetings and so on. The government are not necessarily in favour of the definition that's been put forward, and actually there seems to be strong indicators coming from other governments as well, other countries, that they want to sort of water it down and not have it as robust as it initially started out. So the hope is really fading in terms of that. So I think the last point I would make is, if you are a worker on a building site, or indeed in any other place of employment where this is, in a sense, widespread practice, people have asked in their questions, well, what are the experiences? And my colleagues will answer on that. But this word fear is quite strong. So if you're a worker on a building site, and even if you know you have been misclassified fairly early in the process, and you turn around and you say to the employer, why did you do that? Because I'm a worker. I'm filling all the control mechanisms and everything else. I'm a worker. Well, the answer that you likely get is, if you don't like it, go somewhere else and take a job. So that's the choice, that's the option that a worker has in reality on the ground. Now, in most cases, that's no choice. In most cases, that's no choice. So I think I leave it at that. I think I've tried to cover in general the main issues that you've raised, and I'd ask refer to my colleagues.
Thank you very much, Patricia. Billy, do you want to go on?
Yes, thank you, Chairman. Yes, and thank you for the opportunity to come before us today and answer various questions that you've put to us. If I may start with the idea around the WRC and various cases that can be taken. And it's true to say you can go to scope, but it's very long-winded, and somebody's rights will not be vindicated within the scope section of the Department of Social Protection. However, if you do forward a case to the WRC in relation to bogus self-employment, the case will be heard, because workers' rights, that's where workers' rights are heard. And not only will the classification be dealt with, but the actual workers' rights will be dealt with on the day. A decision will come out, and we've been very successful recent times on the first one was on a procured site, and I know, Senator Higgins, you mentioned procurement. Schools, Carillion sites, and we found that 6 plasterers were bogusly self-employed, were a loss in terms of no contracts, no holiday pay, no wages, and the sexual employment order hadn't been in at that time, and there was 1 or 2 other issues, and it amounted to a loss between the 6 of them of 20,000. We got the decisions. They were unappealed. They went to both ministers, both the Minister for Finance and the Minister for Social Protection, and we haven't heard anything back from either departments. However, we do note that the company has now been put into liquidation. The decisions have been forwarded to the liquidator, where we hope the Social Insurance Fund will pay out. So that's the state paying twice or maybe 3 times. Recently, we've had another case where a plastering contractor decided to designate a plasterer as a self-employed plasterer, and he registered him every week with the Revenue Commissioners. That is supposed to raise a red flag with the Revenue Commissioners, and on this occasion it didn't. So for every week, this worker, who was a plasterer, was being paid through the ERCT system, and the flag wasn't raised. We took the case, we won the case, and an award of €4,300 was made. It's been unappealed, and the cheque is now, we've received the cheque. But there is an outstanding issue here, both for the Department of Social Protection and the Revenue Commissioners. Number one, the employer's PRSI, but number 2, this worker was classified as a self-employed worker with a 0% tax rate. So there's 3 percentage tax rates with the ERCTC system. There is 0, 20 and 35. So now the state is at a loss in regards to the tax. I don't know whether that tax is going to be recouped, but that's up to the Revenue Commissioners to deal with. Senator Nash, you asked the question in terms of skills gap, and there is a massive skills gap in three disciplines: plastering, painting and bricklaying, and they are 3 of the main trades, have been around for centuries, and are 3 of the main trades in terms of building a house. But yes, young people are not going into those trades for a number of reasons, and I would say the main reason is their parents. So when it comes to filling out their CAO form, and it comes to apprenticeship, mum and dad will say, so we've heard all the horror stories in regards to construction and people not getting paid and people being designated as self-employed with no rights. So why would I want for my child to go in, serve their time as an apprentice plasterer, come out with a National Craft Certificate which isn't recognised anywhere, because the only thing you need to get onto a building site in Ireland is a safe pass. How you get a safe pass, you spend 1 day in a classroom when you have a safe pass. So that's the only qualification to actually get onto a building site. So do I want my child to go through 4 years of that? Absolutely not. So we'll go and we'll see what's available under a degree, arts degree, or whatever the case may be, and that's one of the main reasons. And I can example it this way: on a procured site in Tala, I won't mention the builder, we managed to get 2 positions for 2 young lads, one 20, one 18, as apprentice plasterers with the subcontractor on the site. He treated them abominably. He didn't register them with Sulis, and they were being paid €50 per day, supposedly after tax. We referred it into the WRC, where 2 awards were made amounting to around 8,500 between the 2 workers. Now that's on a procured site where everything has to be right. They're signing a contract from the OGP. There's a section, a clause in it that says sexual employment orders will be adhered to. They sign a declaration on every interim payment that rates of pay have been paid, that pension contributions have been paid, that a death and service benefit is in place, and sick pay, as is necessary under the SEOs, is in place. None of it was in place. So there are no checks and balances. There's an actual culture there where there is no checks and balances. We've recently had 2 meetings with 2 city councils where we identified on the outsourcing of voids, their empty houses from from the council being put out to contractors. So there's a framework and there's a number of contractors on it, and they sign Model Form 15 under the short-term or term refurbishment contract from the OGP. And they're supposed to do a number of things, pay pension contributions, comply with the SEO, comply with all employment law, which includes holidays, redundancy, unfair dismissals, whether they get a statement of the main terms and conditions of employment. So what we discovered was, on one of these sites, one of the contractors had got the job. He then subcontracted it out to another contractor who got the job off him, who in turn subcontracted it out to another contractor who got the job. Now, when we paid the visit, and the visit was made yesterday morning for the second time, we discovered that the contractor who's actually doing the job has two people working for him who are both self-employed, who work from 8 to half 4 and are paid a predetermined wage every day. Now, there's no entrepreneurial skill in that. You can't introduce better management structures to make more money. You can't subcontract the job yourself to make more money. So that's what's happening on procured sites. And there are no checks and balances on procured sites. Nowhere. It's just non-existent. It doesn't happen. We've raised it in 2 city councils. I think I've identified the areas. I think I've identified in terms of scope. Scope do not vindicate rights of workers. They only decide on the designation whether they're self-employed or not. And as Patricia has said, the building industry is a casual industry. So if you put your head above the parapet at any stage, you're marked, and you are marked. And if you continue to look to vindicate your rights, problems will occur for you. And we've had members where that has occurred. So people and workers are very slow to act when their rights are explained to them, particularly in a casual industry. And I'm sure my colleague Seamus will outline that what I'm saying is true, as his members get the same type of treatment. So workers are very slow to vindicate their rights. But the WRC, we believe, is the only avenue that should be pursued for the reasons outlined already, but also on a referral to the WRC, it will be heard. The decision will come within about 2 months. The employer has, or the respondent, if the decision goes against them, will have 42 days to appeal that decision. If they do appeal that decision, it's straight to the Labour Court. From there, and if they're unsuccessful in their appeal, they can only appeal that to the High Court in a point of law. It's over then. There's no this continuous. If you take Mrs. Mahon on one of the cases, the Denny case, which is a seminal case in Ireland, she first started off in the scope section and it was appealed. It went to the High Court and then it went to the Supreme Court. Workers are not going to wait around until the Supreme Court to make up their mind. So the only way to deal with it, in our view, is the WRC.
Thank you, Billy. Seamus?
Thank you very much, Chairman and members of the committee. I would agree with Billy's last point in particular, and as a trade unionist I have long believed that lawyers should be avoided like the pledge. Industrial relations matters should be settled through the industrial relations process. We don't use scope very often. When we do within the union, I have had a positive experience of them on an individual basis, but the state has simply not equipped scope with the powers or the resources to deal with this problem. You asked, is there a fraud? Yes, there is a fraud, but I would also say there is a conspiracy, and there is a conspiracy of silence by the state and has allowed this to happen. And to sort of shrug their shoulders, revisit it about every 10 or 15 years and say nothing to see here. The fact of the matter is that the current criteria in relation to the designation of self-employees, interestingly enough, have their origins in the complaints about the Competition Authority. Because at the early stage, when we were told that setting rates for freelance workers was part of a price-fixing exercise, there was at that time a national social partnership talks were going. And those criteria, which are quite good and quite clear, which define what is a worker, what is an employee, whether you work on the control and direction, were one of the outcomes of the social partnership process. But the state has not taken that seriously. Because no one believes, if you look to his logic conclusion in relation to the construction industry, that a builder is not going in working on the control and direction. He can't say, you know, damn this for a game of soldiers, I'm going to work for someone else tomorrow, or I'm going to, and he can't profit. He can't meet any of those tests. In my own industry, I would have to say that, and I will deal with the overall situation and then make specific reference to RTE. It is important to state that freelance work is legitimate and casual contracts are legitimate, and there is a room and a necessity for the opportunity to go in and work for a number of employees, to take short-time gigs, to work as a production editor in one paper, to work as a columnist in another. And there is a legal framework within that. There is a framework in relation to part-time legislation, in relation to casual workers. All of that exists. And yet, within our industry, we have, both within the national newspaper, the regional press sector and the national media, we have an abuse of the ability to offer contracts for service, bogus self-employed contracts. They're not freelance contracts, and in that sense, I just want to make that distinction in the context of the Competition Authority Act. What are the lessons in relation to that? The Competition Authority Act and the provisions in relation to that, I think, link in to Patricia King's comments in relation to the definition of worker, the need to properly define worker. What's interesting about that piece of legislation is that we may already have to revisit it. We are currently, as a Congress and as Union SIPTU and NUJ in particular, looking at very significant determination which may not even have come across the Senator's desk yet in relation to a complaint lodged by Congress before the Economic and Social Rights Committee of the Council of Europe, taken by us in advance of the legislation being passed before the Houses, which clearly is really useful in terms of saying that you can't use competition law to restrict the rights of workers. On the figures, on the issue of, so I think that the first lesson is on the issue of definition. We are at the stage of recruiting freelancers, of reorganising freelancers. SIPTU and the NUJ have had a joint conference in relation to that. We are examining the rates, but it is quite difficult to make up for 20 years, because it is effectively nearly 20 years, of an inability to represent freelance workers. But I think that the main lesson I would put is not a legislative one, but is that it was proof of what legislators in both the Dáil and Shannon can do working together when you get your teeth into something. And I think that's encouraging from the point of view of this committee. This is the centenary of the ILO, and it will be an interesting legacy of this committee if you could mark that centenary, since everyone's so fond of centenaries at the moment, with some real action on this. Well, that last November's gathering, where Ireland reported the outcome of the Competition Act, passed unanimously by both houses of the Oireachtas. There was an attempt, not just by the Irish Employers Group, but by the international body of employers, to prevent reference from that achievement on the part of the ICTU and the acknowledgement of rights by workers, to have that formally recorded as part of the record of the session. And that says to me that it's not an accident that we have an abuse of bogus self-employment, but rather that it is part of a wider approach by employers. The reason that there are very few complaints in our workforce is quite simple. People are terrified. You spend your life complaining about journalists, some of you at least, and you think that journalists are competent and competent. They are as weak and as vulnerable as any other section of workers. And for the majority of people working in a newspaper or in a radio station or a television station who are offered a contract, it is not an offer. It is the equivalent of a pint or a transfer guard. That's what it is. There's no choice involved. And if you don't sign the contract, you don't have a job. There is an additional dimension in relation to well-paid job posts, and that is that frequently organisations such as the national broadcaster require people, as a condition of their employment, of the offer, to register for VAT because of the size of their earnings. And once you are registered for VAT, you are agreeing, in inverted commas, that you are actually not an employee. And yes, you can go down to the Workplace Relations Commissioner, to the LRC, and I have done it, and try to prove that you are an employee. And the employer who can't afford to pay you on the proper terms has no hesitation in bringing down an army of lawyers and barristers to prove that Mr Dooley agreed that he was a company and he registered for VAT. So one of the reasons why there are so few complaints is that people are afraid, or investigations is that they're afraid to make them. I link the issue within our industry of bogus self-employment to bogus redundancies. Frequently within our industry, and I'm mindful that I'm not going to name companies, we have a situation where workers are offered, again in inverted commas, what is a bogus voluntary redundancy, and then rehired under a contract for service. It's done in such a way that it's a voluntary redundancy. The terms are above the statutory rate, and you are rehired under a name within an indecent period of time. And that's happened, and it's happening it will happen within this city within the next year in one of our large national newspaper groups that I won't name. These are not voluntary redundancies, and everyone goes along, and one person is brought in and is told they are at risk of being made redundant. They are interviewed for the only post, as they're not being interviewed, they're not being made redundant, their post is being made redundant, but they're the only one that holds that post. What do they do in that situation? And it's exactly the same situation when you're offered redundancy. In relation to an inappropriate contract, in relation to the National Public Service Broadcaster, the RTE Trade Union Group is currently engaged in protracted and complex negotiations with RTE on implementation of the Evershed Sutherland Review. We are in fact due to meet senior management tomorrow, but it has been a torturous and extremely difficult period, and I have spent more time in Montrose on this subject than any human being should be required to do. I am reluctant, and you will appreciate that, to comment on specific aspects of ongoing negotiations. But from an NUJ perspective, I do want to acknowledge that the current Director General and the HR Director and the Board have sought to address a legacy of blatant disregard for the employment rights of a significant number of workers over a long period of time. Patricia King is a former member of the RTE Authority who raised this, as did previous trade union nominees over many years. My union, SIP2, the TUG, other TUG affiliates have been highlighting the issue of inappropriate contracts over many years. This morning I read detailed notes of a meeting attended by my Karen O'Loughlin and myself in January 2015, when we both, not for the first time, warned the then HR Director and his staff of the consequences of misclassifying workers. So I do acknowledge the progress. Some progress has been made, but we are not happy with the speed of the progress. RTE's failure to provide appropriate contracts will have consequences for the organisation. I think it's probably useful to remind ourselves that where workers are denied rights, they have a right for retrospection. To remind you of the headline figures in the review, of a total of 433 contractors reviewed, 106 have been assessed as having attributes akin to employment. RTE objects to the term bogus self-employment, so if you would kindly use the phrase attributes akin to employment or attributes which are not akin to employment, that would be very good. There are 51 contractors assessed as having attributes akin to both employment and self-employment, and 276 were assessed as individuals who would not normally be considered as employees and require no further individual review. According to the PAC period review, January to May 2018, there are 472 contracts of service in RTE, 81 are incorporated limited companies. Now, there are a few points I would make here. One is that all broadcasting and media organisations have a fetish about personalities. There is a belief among broadcasting organisations in particular that in some way on-screen talent should be treated differently. I reject that notion, whether in the public service broadcaster or anything else. it has a number of negative consequences. It denies employees, some employees, the opportunity for promotion. It favours people who are on contracts for service or limited companies, and it has potential for discrimination on age and gender. And I have not seen any justification anywhere for offering people contracts for service by virtue of the fact that they perform one job rather than another. Workers who have been denied contracts of employees will in RTE be looking for retrospection, as happens on an ongoing basis in other companies. And I would say to you, returning to the question that has been asked about why people don't put their head above the parapet, and I know my colleagues will have the same experience, one response you will get is we cannot afford to make you an employee. It will cost too much if we have to pay retrospection. You're endangering the profitability of the company. Hit me now with the retrospection bill in my arms. But what we have been very clear is that workers who have been denied rights are under no obligation to subsidise in any way the cost of correcting a wrong, and that is also reflected within the Congress submission. I do want to stress that the problem is not confined to RTE. It has been rampant in many media organisations, mainly but not exclusively those which are not unionised. And the problems which Patricia and Billy have identified are also linked to inadequate protection arising from trade union membership or refusal to recognise unions. It is linked to bogus redundancies, and it is also linked in many ways to the operation of outsourcing programmes within our industry, where people have been forced out of work and then offered to work for a company which, on the face of it, has no connection with the original parent company, but when you dig deep enough, you find that actually they're all part of a family.
Mr. Dooley. Mr. O'Hanlon.
Good morning, everybody. And again, like my colleagues, thanks very much for the opportunity to outline to you what are developments in the aviation sector. And I don't know whether people have a view whether it's unusual that you would think of somebody as being in bogus self-employment as a pilot in the airline industry, but certainly I think it was Deputy Collins asked, is this a growing sector? You know, what sector is this growing in? Clearly we see that growing in aviation. One company in particular, Ryanair, you would be looking at upwards of over 50% of the pilots are on self-employment contracts. And for all the reasons that Patricia and my colleagues have outlined around the whole financial benefits of that, one of the primary reasons, and I think Senator Nash asked this question about how does that impact on our ability to collectively bargain? Well, you know, it's very obvious that the strategy is designed to keep people in these contracts of employment where they can't be collectively represented like the colleagues who are employed as direct pilots, and that is an attempt to deliberately influence our ability to be able to improve terms and conditions, issues around recognition, and also to enforce statutory rights that the pilots would have. So it is a growing area. It is not linked to the low-cost carriers. It is a significant issue in the low-cost carriers. There's no doubt about that across the board. Ryanair are not unique in this area. But it is also there with some of the legacy airlines. And it will increase when the legacy airlines start to having to compete on certain routes, and the costs that they're paying and incurring are significantly more than those who have these bogus self-employment contracts. So there's only one way this is going. And you know, any analogies of airlines and going up, you know, are just by coincidence, but that's where it's going. In a study done by Ghent University in Belgium in 2015, 1 in 6 pilots across Europe are now on bogus self-employment contracts. That information was backed up by the London School of Economics research done in 2016. So when you're looking at that trend, it's very easy to see that those airlines who have direct employment, and we would describe as responsible airlines who are fulfilling their obligations, both PRSI, tax, compliance with employment law, if this is not changed, they're going to have to compete in that area. And we'll see a continuing growth of this area, this particular development that we're seeing in low-cost airlines. This will creep into some of the larger airlines, into those that do have good agreements with trade unions, that do negotiate, because they're going to be saying to us quite legitimately, what are you doing about that? And if we're seen to be doing nothing, they're going to say, well, we're now competing in that field. So therefore, we're going to have to go down a similar road. And when you look to the extent, and I think again it was Deputy Collins, and unfortunately she's not here, the Irish Airline Pilots Association, IALPA, made an extremely detailed presentation to the department back in 2013. And it's particularly focused on one particular airline in relation to Ryanair. But it demonstrated the extent to which people or these organisations were willing to go to create these bogus self-employments. So if I just give you an example of how far they're willing to take this to avoid detection of people being seen as direct employees. And I think it's important to state that in all these cases where people are on these bogus self-employment contracts, they're absolutely 100% under the control of the airline. They absolutely determine what routes they fly, when they're available. There's obligations with regard to the maximum number of flying hours a pilot can do per annum, which is 900. You'll have somebody like Ryanair will recruit somebody in April, absolutely max them out during the peak period. So when that person then is let go, their flying hours are used up and they can't gain other employment. So that's open to them to do that. That gives them a significant competitive advantage over the competitors to be able to do those type of things. But just if you focus on some of the extent that they're willing to go, in the case of the Ryanair one, they'll actually use a UK contract as a hiring agency. And they've two, I'll avoid going into the names, they were mentioned in the department back in 2013, but they've two particular companies that they use to do this. They're based in the UK and they're not regulated by aviation authorities, neither of them. The pilots are then part of a limited company. So they set the pilots up in a limited company and they have an accountant who acts as the financial director. And you may have 2 or 3 pilots actually in this limited company. Ryanair is not party to the contract. The pilot provides services directly and exclusively to Ryanair, totally and absolutely under their control. And when the nature of the contract is that when they decide they dispense with your service or the contract comes to an end, you have no recourse to any employment legislation, no protections whatsoever. And I know Seamus and Billy have touched on the various different employment rights. Certainly the pilots in the airline industry don't have any of those protections. But when you look at that type of elaborate setting up to avoid that obligation, that tells you the benefits that must be there to do that. It's very obvious what organisation would go to that extent to bring somebody in if there wasn't something to be gained with that. The issue of us being able to collectively bargain, and again, Seamus, I think, ended his presentation in relation to it. When you have clauses that are contained in contracts of employment, and this exists for both direct and non-direct employees of some of these airlines, where your home base can be literally changed overnight. Today you're based in Dublin, tomorrow you're in Poland, and that's where you're going to work from. And you have no method of preventing that happening. That threat alone will stop people wanting to raise any issues about that. The fact that you would have to move your family, wife, children, husband, or whatever else, partner, to the other side of Europe, to be based there, is enough to keep any worker quiet, and it has that effect. And we see that. And we had a recent dispute with one of the low-cost airlines last year, where clearly our ability to organise those workers was extremely limited. But that was deliberately so. That was designed that way, so they get all the benefits of the cost, the competitive advantage it gives them. It also prevents workers joining trade unions, because they're not direct employees, so they're prevented from doing that. Prevents us being able to represent them. And when and if the only recourse they have is to challenge their employment status, they run the risk then of being shipped anywhere across Europe as their new home base. So there are major challenges for us in the aviation sector, but I think it's important to emphasise it is not unique to Ryanair. We have it in Norwegian, we have it in all the other low-cost carriers because they're directly competing with the other low-cost. But we are seeing evidence of it in the legacy airlines as well. And recently I spoke to my colleague who represents the cabin crew staff in the aviation sector, and there are now examples of bogus self-employment contracts in cabin crew in one of the low-cost airlines in Poland. So again, that's the start of it. It'll creep in, and then the other low-cost airlines will be in the same position to be able to do something about that. So certainly, Deputy Collins, you asked for where is the sector. Aviation is definitely one of those sectors, and you can see the implications of that across the board that we're trying to deal with.
Could I just, Chair,
you can, of course.
On that point of aviation, which I know a little bit about as well, there is a complexity in that both the joint investigation by the Department of the consultative group that they set up looking at this, and indeed the CNAG's report would only have looked at the misclassification of workers in the ordinary sense, and indeed both reports looked at the personal services companies and the intermediate processes that can be put in place, the personal services companies and the managed services companies, which are more common in, say, the communications side. But actually, in terms of aviation, the models that have been developed are much more complex, and we've had advice that the remedy lies in company law because of the manner in which these, I just wanted to say that. And the second point to say to you is that maybe in the last year in the aviation sector, and some of the disputes and some of the resolutions to those have demonstrated that from a collective bargaining point of view, you actually can reach agreement. An agreement has been reached in terms of, for direct employees, and indeed it covers quite a number of people, in terms of trying to remove the pillars of fear for people and putting in, I suppose, mechanisms to try and give people a fairness in how their employment locations are distributed and so on. That was one of the very key pieces in a recent dispute that I was involved in myself, and that shows you the value of actually a collective bargaining outcome whereby you can deal with the employer directly and try and find a common response to those issues. So the same outcome happens no matter how complex the model. The worker is denied, as Brendan has said, all of the employment rights legislation and indeed the social welfare and so on contributions and the results of not having your contributions and so on. But somewhat the models can be so complex that company law can be affected or be the remedy rather than the pieces that we've just, the competition that we've just talked about here.
Thank you. Colleagues, if there are any brief comments, I'll take supplementaries. I'd ask you to keep them brief. Deputy Brady.
No, listen, just to say thank you very much for that. I think it was very insightful, very, very useful, and it certainly blows completely out of the water the myth by the department, by the minister, that this, bogus self-employment isn't extensive across the state, and certainly the evidence you've outlined, certainly hits that point home. Just a couple of points there. Seamus spoke about RTE and the difficulties there, and I think it's important, and you're dead right, that bogus self-employment isn't just confined to the state broadcaster, that it is endemic right across the sector. And I'm aware, in this House, people who operate the communications, the cameras in this place are currently engaged in scoping exercises as well. So, it's in here, it's in this institute, and that's how extensive the problem actually is. Just in relation to the figure of conservative figure of 240 million that Patricia outlined there in terms of the frauding of tax and PRSI in the construction sector, and that's just in one sector, and I assume that's on an annual basis. And it wouldn't take an Einstein to do the maths if you were to multiply that across all of the sectors. We're possibly dealing with a figure, a fraud, an annual fraud of in excess of €1 billion, being a conservative figure. You know, €1 billion being frauded of this state in terms of tax and PRSI. And yet we go through, you know, all of the areas there, the people engaged in scope, the Joint Investigations Unit, and we see the minuscule numbers of people. So, you know, just again, the thank yous for that. And just the final point, and I think it's important, you know, in terms of state procurement, and I think, you know, it's a job of work for this committee now to delve into that area as well. But I think Billy mentioned Curran, you know, 6 workers that had been engaged there, and I'm aware of some of those people, and I'm aware of, you know, the difficulties, not just in terms of Curran, because workers, people I know, were engaged in another state procurement project in my own constituency, a housing construction project that got into financial difficulties at the other side of Christmas. So some of those people were caught up in Curran and in that as well. So we see in terms of workers' rights, but also in terms of redundancy and all of the other implications. And some of those people were caught up in that process twice on state projects. And that's, you know, should be enough for the department to lose this false sense that, you know, it isn't endemic, it isn't widespread, because it is. That's the reality.
Thank you, Deputy Brady. Deputy Collins.
I think you covered the main areas that we really need to be covering. Now we're hoping to bring in workers from the English language workforce and other areas as well to try and delve down to that too, and hopefully come up with something. Well, we will come up with something at this committee to put forward in legislation and look at particularly that thing you're talking about, the company law in relation to the pilots and that. I think that's something that we'll have to look at as well. I'd just like to thank you very much for coming in and continue to work with us over the next period of time to make sure we make a difference on this.
Senator Higgins.
Thank you very much. I'd like, Seamus, you mentioned the centenary of the ILO, and of course we're in the centenary of the programme of the First Dáil as well, and we have in that which very much clearly makes it clear that the government should be seeking the cooperation of other governments and other countries in determining a standard of social and industrial legislation with general and lasting improvement in the conditions under which the working classes live and labour. So I think it's a double centenary incentive maybe for us to ensure that we are in the tide of improvement rather than the extraordinary speed which bad practice tends to spread, as I think was outlined very eloquently by Mr Hanlon. I also want to thank very much the clarity around the issue of repercussions, and it was very interesting because this is even admitted by the Scope Unit when they presented to us. It's a very small line in their presentation, but they talked about you know, the 10,000 who visited their site, 10,500 visiting their site, of which only translates into a very small numbers of phone calls and emails, and then within them evidence that, and this is quoting the department, evidence that people want anonymity and fear repercussions. And I think that's very clear. And then it can be frustrating when we raise this issue, perhaps directly with the Minister. We're constantly being told, bring me the examples, bring me the examples. But what's very clear is that fear of repercussion. And I think delving into those issues and how we can address them is important. You mentioned the issues of, in terms of definitions, which I think is key. I'd love if we could maybe have a follow-up note specifically around that directive and in terms of how we can maybe contribute in some way specifically towards pressing Ireland's position in relation to the European directive and the definitions. And I was interested by one of the phrases when you mentioned those who are labour only and under the control of, and perhaps there is also with every definition, you know, there are loopholes. And I know there's, for example, is somebody labour only if they're required to bring certain amounts of equipment, you know, so how that gets kind of shifted around is something I would be interested in, so we can try to guard against it in terms of definitions. Particularly, I wanted to touch on the area of procurement, public procurement in particular, and it's an area I've interest in. I'm bringing legislation in this area myself, I hope later in spring. I think it's one. We addressed the issue of effective, what I would describe as fraud within public procurement, or you know, which is described by Patricia King. But two other issues I'd like to be touched on in that. One is the issue of at the point of contract. So there's a problem where that contract is not fulfilled, but in that point of contract, for example, are there situations where lowest cost is being used when price, quality ratio should be used with a stronger emphasis on quality in terms of employment standards? Also in terms of, and again, Mr. O'Hanlon, I know you represent, first represent many public service workers as well. The employment control framework and the constraints of recession allowed for a lot of contracting out in the public sector, which has seemed to linger now and become, in fact, if you could comment on areas where you believe we should be moving out of the public procurement area and into direct employment within the public sector. And I think it was mentioned even in the Oireachtas, we have situations here for people who are working in situations where they should be employed because they have one employer. And it's not in a work that is overly seasonal, not that it's work that is going away. So if you could just touch on those issues.
Thank you.
My very last, very quick question. Red flags. I was very interested by what you mentioned about red flags, repeat registration. And it strikes me that bogus redundancies are large-scale redundancies. Apparently should be another red flag. And perhaps if you might indicate other red flags that we should be marking as triggering effectively investigation in advance rather than waiting for individuals, as we said, to bring cases.
Thank you, Senator Higgins.
Thank you.
Senator Nash, have you any concluding? You're fine. Before I let, if you just bear with me one moment, I was going to let you conclude if any of your colleagues wanted to comment on any of the issues and before that.
Well, I think Senator Higgins has raised a number of issues, and rather than giving, now I would be anxious that we would do justice to it, so I think that the group and through the Secretary of Congress could actually either arrange a further presentation or a written submission raising some of those issues.
On those specifics
would be very useful. Thank you.
Thank you. Mr. Wall.
Yeah, one thing that I didn't mention, and I mentioned it briefly, but I did touch upon it in terms of qualifications and the whole idea of the apprenticeship and the cause of bogus self-employment as nobody's coming into apprenticeship. There is, as it exists at the moment on the Isle of Man, a register of qualified tradespeople or craftspeople. And that doesn't exist on this island. And I believe that a register of qualified tradespeople, that when somebody comes out from serving their time, that they go on a register and they're registered in the state as those who have qualifications, would be very helpful in actually tackling bogus self-employment.
Well, Mr. O'Hanlon, any conclusions?
I suppose briefly in relation to Senator Higgins' point around outsourcing in the public sector, I mean, certainly Force is opposed to it. There's no doubt that it grew to some extent during the whole moratorium and the downturn in the economy, but I suppose what we're trying to do with various places, I deal with a number of public sector state agencies. Myself, we're trying to gradually make sure that the core work is carried out by direct employees. So, thank you.
And Ms. King.
Yeah, just finally, just to say, in answer in particular to Senator Higgins, just to say, I think that the Office of Government Public Procurement have a number of questions that they might be able to answer you in terms of this whole issue of how all these matters are monitored and controlled within their model of public procurement. And so it would seem to me that a valuable piece of time could be deployed in getting some of those answers. Now, I will say we have tried very hard to get some of those answers, and they don't feel obliged to answer us quite directly with the answers we put or the questions we put to them, but that you might have more success in relation to that. The other thing I would say to you is that in thanking you for the opportunity, we think that there should be a piece of legislation to control all of this. And we do recognise that during the course of the discussions, debate and otherwise on the Miscellaneous Provisions Bill, which has since become a piece of legislation, which we were very active in lobbying for, there were some very, I thought, progressive amendments and progressive proposals put by various parties in relation to bogus self-employment. And it was unfortunate that we found ourselves in a position where we had to do it because our utmost concern was that that piece of legislation actually went through, and we felt that there was maybe a view that if it was going to contain the bogus self-employment issues, it was going to delay the whole piece. We needed the whole piece for other reasons, to protect workers in terms of banded hours and everything else. And to be fair, deputies from various parties cooperated with us in terms of the passage of that bill through. That is not to negate in any way the value of the content of the proposals and indeed the private members' bills that have come from senators and deputies in relation to this matter of bogus self-employment. And we would like to see this committee work towards trying to convince the government, or whatever it is you do in terms of that, to allow us to arrive at a stage where we have a piece of legislation that regulates all of this. Thank you very much.
First of all, I'd like to thank the witnesses, all of you, for your, I suppose, your direct responses. They were very open, very informative and very frank. Just to put you in the picture, this is a piece of work around bogus self-employment that the committee have undertaken. This is the second session that we've had, and over the coming months we will have other witnesses to conclude with a report and recommendations within a number of months. We haven't restricted time around it, because what we find is one meeting can often lead to an indication of additional witnesses, and we want to be open, we want to be thorough, but we do want to make very, very specific recommendations. And one thing that's very clear from the evidence presented here today was the capacity of the existing system to identify people who are in bogus self-employment contracts isn't sufficient. The numbers simply don't tally. Whether it's total numbers or sectoral numbers, there is a deficiency in the system, and that's a cause of concern, because we can't rely on the state numbers. They underestimate the issue. And there is a piece of work for the committee to do. From your own point of view, over the coming months, if there's, and I mean short number of months, if there's further information or evidence that you think would be of use to the committee and its work, please feel free to correspond with us and stay in touch. And a report will be published in a few months' time. So once again, on behalf of the committee, Ms King, Mr O'Hanlon, Mr Wall, Mr Dooley, thank you very much for your time coming here today and your presentation. Members, we will conclude our business for today, and we adjourn until the 14th of February. Gurmagat.